Good morning, everybody. All right, we are back on. Defendants are present, represented by counsel. When we broke last night, we were addressing motions before the court. The most efficient way to go about this is the state had indicated wanted a little bit of time to take a look at the demur on count 7. Is the state of any additional argument after reviewing the demur that had been filed on behalf of Mr. Bryan?
No additional argument. We stand on what we had originally filed and on the court's order on the demur to count 7, which is, it tracks the language of the statute and it informs the defendants of what they are to defend against, and therefore it is sufficient and there's no reason to grant the demur to the indictment on count 7.
All right. Go ahead and address that. Then let's get through any additional motions and I'll start addressing the motions as we go. I probably should have gone around and asked the question that normally leads to some time before the court. Before we get started, anything from the state? From Travis McMichael?
No,
From Greg McMichael?
No, we're ready for our motion.
And from Mr. Bryan?
Yeah, you got it.
Motions then. I'll just go around, same.
Mr. Hogan's going to speak for both Greg and Travis McMichael.
Your Honor, at this time, on behalf of Greg McMichael, and I will speak for Travis McMichael with permission of co-defendants' counsel, and invite them to add anything you may wish to add that does apply specifically to Travis that I may not mention, but I'm going to try to cover both in this motion for directed verdict of acquittal. And I'll start with the statute that applies to such a motion and then go through the counts in the indictment that I think we have some argument to make regarding it. First, the statute. It's OCGA 1791A, which says, where there is no conflict in the evidence and the evidence introduced with all reasonable deductions and inferences therefrom shall demand a verdict of acquittal or not guilty as to the entire offense or to some particular count of or offense, the court may direct the verdict of acquittal to which the defendant is entitled under the evidence and may allow the trial to proceed only as to the counts or offenses remaining, if any. So I start with count 1, and let me get my indictment up here, which is malice murder. And to make this argument for acquittal on malice murder, allow me to review initially what the elements of that offense are, and then talk about the evidence in the case. The statute, of course, is 1651 A and B, and 1651 A says a person commits the offense of murder when he unlawfully and with malice aforethought, either express or implied, causes the death of another human being. So starting with just subsection A, malice, of course, in Georgia law means a specific intent crime as opposed to a general intent crime. And in a specific intent crime, the subjective desire of the defendant is to bring about the exact illegal consequence that his action is intended to produce. So in a malice murder count, that means that that malice means the defendant has the specific intent to commit an act that the cause of which is the death of another person, and that result was the desired result. It was not an unintended consequence, as we'll see is the case with felony murder. So malice, that sort of specific intent, can be shown in two ways by proof, and that's subparagraph B in 1651. And that paragraph indicates two types of proof of this malice, the specific intent. Of course, I always mention that as the definition of malice because it's certainly confusing to jurors, but that's a different issue for later when we talk about charges. But it means no intent, no ill will or hatred, of course, but it's just a specific intent. Two types. Express malice is that deliberate intention unlawfully to take the life of another human being, which is manifested by external circumstances capable of proof. Now, case law indicates that would be things like verbal threats, lying in wait, the kind of circumstances or actions for which the state can produce evidence that says this person had express malice. It's out there in the world for us to see it. We can hear it. We can determine it from the circumstances in which the killing occurred. The other type of malice, much more sticky, is malice shall be implied where no considerable provocation appears and where all the circumstances of the killing show an abandoned and malignant heart. So to further define that type of malice, I need to go to a different place here in my notes to look for a definition of implied malice in our law. What we're looking for is that specific intent to kill where there are no external circumstances capable of proof, but inferences must be made. It's implied. And first of all, you have to find that there's no considerable provocation, which would be, say, voluntary manslaughter, and there's no other justification for it. And then in one of our cases under Georgia law, which is Parker v. State, and I'll get the site here, 270 Georgia 256, a 1988 case. Essentially in Parker, the court tries to define that poetic metaphor we find in the implied malice sentence, which is the abandoned and malignant heart. I find it of interest that there are only 4 states left out of 50 that use that phrase in their definition of murder. Abandoned and malignant heart, having its roots somewhere in the dark recesses of medieval English, but here it is still in Georgia. Idaho, Nevada, and California are the other 3 states that still use that phrase. And so Georgia, in attempting to say what it means, says that it's a reckless disregard for human life. And Justice Hunstein in Parker v. State tries to give some sort of definition for it. It's not a substitute for implied malice. That is, reckless disregard is not a lower mental state or lower standard of proof. It's not equivalent. It's, as she says in this opinion, a special concurring opinion, she says the difference between instructing a jury that a presumption of malice may arise from reckless conduct, and this is for malice murder, and instructing them that reckless conduct and malice are equivalents that can be substituted for one another is not just a matter of mere semantics. A jury is entitled to be instructed how to determine a defendant's state of mind based on the evidence adduced. It is not entitled to be instructed that a lesser mental culpability may be substituted for the required higher mental culpability. And then she goes on to criticize the charge given in that case in Parker. But what it comes down to, and it's even cited later in a U.S. Supreme Court case, actually it was a case earlier than Parker, and also an attempt by Justice Brennan to define it. And the case is Arave, I'm sorry, let me start that over. A-R-A-V-E, Arave v. Creech, C-R-E-E-C-H, 507 U.S. 463, a 1993 case. Justice Brennan wrote this: homicides committed without considerable provocation or under circumstances demonstrating an abandoned and malignant heart, a term of art that refers to unintentional homicide committed with extreme recklessness. And then I just use ellipsis there because he goes on to another matter. But the examples given would be, say, somebody shooting a gun into a crowd of people. You aren't intending to kill any specific person, but you certainly know by that reckless act somebody will die. Or driving a car into a crowd at a protest rally. Somebody's going to die. This could be an abandoned and malignant heart. So, that all aside, now the facts of our case, going back to the standard of 1791A, where directed verdicts premised upon no conflict in the evidence, and all reasonable deductions and inferences therefrom. In this case, the state's case in chief, which we've just now heard for the last week and a half, the express malice does not seem to be there. Speaking about Travis McMichael in particular, he's not saying anything or doing anything that could be provable by external circumstances to be express malice. And as we've all seen in the video, the shooting doesn't occur until he and Ahmaud Arbery are locked up in mortal combat, hand to hand, face to face, and in contact with one another, with a gunshot wound that's fatal, that's close contact or near close contact, 1 to 3 inches away. Now, none of that is in dispute. There's no conflict in the evidence there. Obviously, the issue that we expect will go to the jury is whether that was an act of self-defense or whether it's some felony murder, and there are counts in here that address that. There is a pair of counts that talk about using a shotgun as an aggravated assault which results in the death, and that's felony murder. Those are 2 separate counts in this indictment. It's always interesting, too, that malice murder added in the same case with felony murder, while not legally inconsistent, and, you know, of course, George has done away with the concept of legally inconsistent verdicts, is somewhat logically inconsistent. When you ask a jury to consider finding a defendant guilty of malice murder based on proof you think you have, if you're the state, that he specifically intended by his act to cause the death of the person who died, and at the same time argue to them, but hey, also consider that he used a shotgun in an aggravated assault without malice, as the felony murder statute says, and the unintended consequence of that aggravated assault was the death of another person, therefore it's bootstrapped up into felony murder. So that is the argument against count 1 under 1791A as a count that should not be presented to the jury because there is no conflict in the evidence. All of the reasonable deductions and inferences from the evidence do not support a finding by a rational trier of fact that express or implied malice have been exhibited here in the act of shooting Ahmaud Arbery. Now, Your Honor, I can go on to each of the other challenges in turn or stop.
Let's go ahead and get the entire
Okay.
motion out.
The second challenge is to the combination of counts 5 and 9. And